Okay, let's get started. Welcome everyone, and thank you for joining us virtually this evening for what we hope will be an eventful, will be an eventful and informative presentation for landlords and tenants in the City of Richmond. My name is Monica Bejarano, and I am a Rent Program Services Analyst. Today, Rent Program Services Analyst Magali Chavez will be conducting this evening's presentation. Before we get started, I would like to share some logistical information. Please note this presentation has been posted on the website at www.richmondrent.org/workshops for your reference. I will provide the link in the chat section on the bottom of your screen. Please also note that this presentation is being recorded, and we hope to post the recording on our workshop page as well. If you have any questions on a particular topic discussed today, we ask that you type your questions into the Q&A function on the bottom of your screen, and we will address your questions at the end. If you have any specific questions, we ask that you contact the Rent Program to discuss your questions with a Rent Program Services Analyst. Without further ado, I would now like to introduce Magali Chavez.
Hi, everyone. Thank you for being here with us today. I will be giving the presentation on how to file a rent adjustment petition. Today's presentation or webinar is going to be a little bit different. Given the technology in Zoom, we're actually going to be showing you how to access the website and the forms through share screen and kind of walking you through the actual forms themselves. So that should be a little bit new and also give you a little bit more context on the actual petition process. So let's go ahead and get started. I know that many of you are here today to find out how to file the petition, but in order to do that, I think it's important to get a little bit of context and get a little bit of foundation of what the rent ordinance is and what it does, and the different sections of the rent ordinance. So I think it's important to understand before we begin. So I'm just going to walk you through some of it. So we're going to discuss the purpose of the ordinance, kind of quickly overview the rent ordinance or the Richmond rent ordinance, which properties are covered under the rent ordinance. So that's very important because not all units subject to the rent ordinance can file a petition. So we'll also discuss who can file a rent adjustment petition. We're going to be breaking down tenant and landlord rent adjustment petitions, how to file the petition, and give you a quick overview of the petition process itself. So let's go ahead and get started. So the purpose of the rent ordinance is really to promote neighborhood and community stability, healthy housing, and affordability for renters in the City of Richmond by controlling excessive rent increases and arbitrary evictions to the greatest extent allowable under California law, while also ensuring landlords a fair return. And this is done through the petition process. So let's break down the ordinance. The Richmond rent ordinance has two sections. The first section is the rent control section. What this means is that rents are regulated, and we use a term called the maximum allowable rent, or also referred to as the MAR. You can think of the MAR as the ceiling, and the maximum allowable rent is calculating by taking the base rent, annual general adjustments, which is the cost of living increase every year, and any allowable individual rent adjustment that is ordered by the hearing examiner, or also known as the petition process. So for a little bit more detail, the base rent is the rent that was in effect as of July 21st, 2015. So that's the base rent. Or if the tenant moved in after July 21st, 2015, it's the rent that they paid their first month. So you'll hear the term base rent a lot, and it's actually a very important term. So it's important for you to know that. Then there is also the annual general adjustment, which is referred to as the AGA. And this is 100% of the consumer price index in the Bay Area, or essentially the inflation rate. So every year, the board approves and announces the annual general adjustment. It goes into effect September 1st of every year. This past year, it was an exception given the pandemic because there is a Contra Costa County order in effect. But the same way the rent board announced it and approved it September 1st for 2.9% in 2020. And so that's changing every year with inflation. And then there's a petition process, which is the individual rent adjustment. And it's really a mechanism to increase or decrease the MAR, or the maximum allowable rent, based on reasons permitted by the rent ordinance, and more detail the regulations that we have. So that's really the rent control process. Then on the other side, there is just cause for eviction protections. Almost all rentals in the city of Richmond are subject to just cause for eviction protections, with the exception of if the unit is fully exempt. So just cause for eviction protections are pretty wide to all rental units, or almost all rental units. And what this means is that a landlord needs to have one of the 8 just causes to terminate tenancy. And so there are 8. We won't be going over the just causes in detail today, but there are other webinars or other workshops that you can view on our workshops page, or we have a lot of other information on our website if you do have questions about just cause. But essentially, it's failure to pay rent, breach of the lease, nuisance, and failure to give access. Those first 4 are what are called at-fault evictions, meaning that the owner needs one of those just causes to start an eviction. The failure to pay rent right now, eviction is being handled by the state law. So there are certain other requirements there. Given the pandemic, we had a workshop last month where we discussed that state law. So if you have questions around that, also make sure to check out our website, and under the workshops page, we have a lot of information there, and we go over that process. So like I said, the first 4 are what are called at-fault evictions. Then the other 4 are no-fault evictions, meaning that the tenant isn't doing anything wrong, but for those specific 4 reasons, the owner can regain possession of the property. And that's temporary vacancy to undertake substantial repairs. There's owner move-in, there's withdrawal from the rental market, and then there's also temporary tenancy. All 4 of these are currently not allowed because there is a Contra Costa County order. So given the pandemic, there is a lot of new laws that are impacting the way that our process and the rent ordinance is being managed or being implemented, especially around evictions and also rent increases. So if you have questions about that, also feel free to contact the rent program or the county. Okay, so let's move forward. What properties are covered by the rent ordinance? So like I said, this is very important because not all properties are covered the same way. So the first properties are what are called fully covered properties. And this is controlled rental units, which means that rent control and just cause for evictions apply. And these are properties that are multi-unit properties, and they were built on or before February 1st, 1995. Then there are partially covered properties, which are only properties that are under just cause for eviction protections. They are not rent controlled. These are properties that are subsidized units, so they're under Section 8 tenancies or low-income housing tax credit, generally known as affordable housing units, because they have already some type of government supervision on the rent. The rent program doesn't double regulate them. So they're only subject to just cause. Then there are properties with one dwelling unit on one parcel. It's very important that we follow the terminology of properties with one dwelling unit on one parcel, because these are typically properties that people call single family homes. But the city of Richmond actually has a lot of properties where it's like the title say a single family home, but the owner has added an ADU, or they have converted the garage, or they have subdivided the property. And that sometimes causes exemptions under Costa-Hawkins law. And so if there is more than one dwelling unit on the property and it was built before 1995, it's possible that that property might fall under rent control, even though some people might consider it a single family home. So it's really about how many dwelling units are on the property. So that's important to know. Then there are condominiums, or what is called new construction, which is anything that's constructed after February 1st, 1995. A quick note is that Costa-Hawkins requires units to be permitted with a certificate of occupancy. So the property will need to show that it was constructed with a certificate of occupancy after 1995. Then lastly, these are properties that are considered fully exempt, which means that they have no rent control and no just cause for eviction protections. These are properties where the landlord and tenant share a kitchen and or bath. So usually this is properties where like I am the owner of a house and I have like multiple rooms, like a 3-4 bedroom apartment. I'm sorry, a three bedroom house, and I decide to rent out a bedroom, for additional income. But the tenant and I share a kitchen and or bath together. So what that means is that the ordinance exempts these types of rental units. Then there are single family homes where a permitted ADU was added and the main house is owner occupied. So it's the same or a similar situation. I, as the owner, live in the main house and I decided to construct a permitted ADU with the city in the back. And so that property would be considered fully exempt if it is a permitted ADU. And then there are retirement homes. The permitted ADU is an important distinction because if it's not permitted, then it's potentially falling under rent control. And so those are important caveats to know. So in our next slide, we have I'm not going to go over this in too much detail, but we have, like the depictions that show potentially what your property falls under for ADUs. So if the main house is owner, like for example, this one, if the main house is owner occupied and there's a tenant in the back, this section means main house and permitted ADU. The ADU is exempt from rent control and just cause. But if there is an owner occupied property and the back unit is not permitted, then the second unit is under rent control and just cause, right? So like the little back ADU is under rent control and just cause. So you can have different scenarios based on who lives in the main house and whether it's permitted or not. So if you have questions about that, you can review this slide. And if you still need additional information, you can contact the rent program. Or if you want additional information about the ADU requirements, or if you want to know if the unit is permitted or not, you can contact the planning division and their number is here. They are the ones that manage the permit process. So let's move forward. So now that we've discussed who qualifies to be under rent control, or who can or what properties are subject to rent control, that directly impacts who can file a petition, because the rent program is responsible or is able to administrate the rents of units that are under rent control, and only the units that are under rent control. So who can file a rent adjustment petition? It's any tenant or landlord that is subject to rent control provisions of the rent ordinance. So these are units that are under rent control that are considered fully covered units, meaning that rent control and just cause for eviction applies. There are also cases where the tenant believes that their unit should be subject to rent control provisions, but are unsure. They can also file a petition. And these are cases usually where it involves homes that have been subdivided, like I was referring to the single family homes, right? So the house has been subdivided where now it's technically, a single family house, but the houses have been subdivided. So there's actually 2 dwelling units. So there's 2 bathrooms, 2 kitchens, 2 separate sleeping areas, different entrances. So at that point, the tenant can file a petition, and based on their documentation, the evidence, the facts, the hearing examiner can make a determination of like, yes, this is considered a dwelling unit, or no, it's not. And depending on those circumstances, it might fall under rent control. The same thing occurs with converted garages, or if there is an additional dwelling unit, and the ADU is going to be dependent on whether it's permitted or not. So tenants or landlords may file the petition themselves or have a representative file for them. Unfortunately, units that are not subject to rent control may not file a rent adjustment petition, again, because the rent program does not have administrative power over units that are not under rent control. And so these are usually properties that are only under just cause for eviction protections, such as single family homes. But remember that that is only one dwelling unit on the property. Condominiums, any rentals that are subsidized by the government, such as Section 8 or tax credit units. So if you're not sure if you qualify, or if you have a situation where you're kind of like, well, my unit is subdivided, or, I live in the back, I live in a studio in the back, or I live in a converted garage. Always feel free to contact the rent program. And, if you speak to a housing counselor, or also officially a rent program services analyst, will be better able to guide you on the steps that you can take. If you're a tenant, it would be filing a petition. If you're an owner, it would be filing an administrative determination. So let's move forward. So let's discuss the tenant rent adjustment petitions. So in total, there are 3 tenant rent adjustment petitions. The first is what we call attachment A, and this is a petition for excessive rent due to failure on behalf of the landlord to roll back the rent. So what this means is that the ordinance considers the base rent what the tenant was paying on July 21st, 2015. So there were situations when the rent ordinance went into effect and when the rent program opened, that between July 2015 and the beginning of 2017, the owners had raised the rent, but they never returned it back to what the original base rent was. So the tenant could come in and say, well, my base rent was never corrected, and now I'm being charged this additional rent. These cases don't happen as often now because it's been several years since the rent program began. But when the rent program began, this is a much more common issue. And then the other reason is that the owner is simply charging rent above the maximum allowable rent. This is what is more common, right? That let's say the AGA is 3%, but the owner does a 5% increase instead, or something like that. For some reason, there is some charge above the maximum allowable rent. And so if a tenant believes that they are being charged above the maximum allowable rent, they can file a petition, which is attachment A. Then there is attachment B, and this is a petition to reduce the rent due to decrease in space, services, and or habitability. So an example of services is sometimes the landlord says you can no longer use the parking structure or the parking lot. Right, but the tenant has a parking spot in their lease. So the tenant can say, well, this service is being reduced from my lease. Another example for habitability, the most common one is mold. So the tenant can say, I have habitability issues in my unit. The basic promise of having a habitable unit is not being met on the landlord's behalf. And so I want to file a petition for reduction in rent due to habitability issues. So those are some examples for attachment B. Then there's attachment C. This petition is available, but I've actually never seen a case for this one. So it's a petition to reduce the rent due to a reduction in the number of tenants allowed. So an example of this is, let's say a tenant lives in the unit. It's like themselves and their partner, they live in a 1-bedroom apartment. So it's 2 people in a 1-bedroom apartment. And they, like for some reason, the partner leaves and then they vacate the unit. And so they tell the landlord that they are going to replace the tenant. And for some reason, the landlord doesn't want the person to replace the second tenant. And they make a continuous effort to deny all of the people that they want to replace. So the tenant can make the argument that, this second person was helping them with their rent, right? So like if the rent is $1,000, each one of them pay $500. And so the landlord is unreasonably denying them the right to replace the tenant on a 1-to-1 basis as allowed under the ordinance. And so they can make that argument and file a petition, and the rent would be reduced by the percentage of people that the landlord is denying to be added. So if there's 2 people and 1 left, that's a 50% reduction. So it would be a 50% reduction in the rent. There are specific regulations and around each of the petitions, and I've actually never seen attachment C. The most common ones are attachment A and attachment B. So let's move forward with the landlord petitions. So there are technically 4 rent adjustment petitions, but we're not going to discuss the 4th one, which is attachment D, because it's not it's a restoration of the AGAs. We're simply going to discuss the petitions where a rent adjustment is actually being considered. So that first one is attachment A, which is the petition to increase the maximum allowable rent, also known as the MAR, due to increase it is due to net due to increases in net operating costs. So this petition in itself is actually really complex. And so to give you a brief overview of what it does is tenants or landlords under the ordinance are entitled to what's called a fair return. So under the ordinance, a fair return is the net operating income that the owner was receiving in 2015. It gets compared to the net operating income that the owner is receiving in what is called the current year. So if you're filing a petition in 2021, the current year is 2020. Because it works similar to taxes, the hearing examiner has to look at the entire calendar year. So the current year would be 2020. So it's going to look at your 2015 net operating income, and it's going to say, okay, let's say the owner in 2015 was receiving $100 net operating income. And obviously these numbers are not correct or represent the truth. It's just for simplicity's sake. So in 2015, the owner was receiving $100 in net operating income. The idea behind a fair return is that the owner perceived this to be a fair return because in 2015 there was no rent control. So this is how much they were collecting. If they weren't happy with what they were collecting, then they could have raised the rent. But because they didn't, this is what's perceived as a fair return. And so what it's going to do, the calculation or the analysis is going to compare it to what the net operating income is in 2020, and it's going to adjust it for inflation. And so in 2020, the inflation rate has been around 16%. So if the owner is receiving anything around less than $116, that's when the hearing examiner can approve a rent increase per unit. Obviously, this explanation is like very oversimplified, but it's just giving you an idea of what the M&Y petition does. It's an analysis of the base year of 2015, compare it to the current year of 2020. It's a mathematical analysis. The owner needs to put forward all of their income and expenses. The petition itself, I think, is like 20 something pages. But that essentially is a petition that's available for owners if they believe that they're not receiving a fair return under the rent ordinance. Then there is attachment B. So this petition is to increase the maximum allowable rent due to increase in number of occupants allowed. However, there are specific caveats. So if you look at this asterisk, there's an asterisk here, right? So a petition for increase in the number of occupants will not be approved if it concerns additional tenants pursuant to regulations of the rent board. So we can get into that when we get to the attachment B. But essentially what it's doing, it's saying the landlord can say, okay, when the tenancy initially began, I approved 2 tenants, and now there are 5 people living there. And so they can file a petition. Obviously, the facts will be reviewed. And if the people that are living there are ones that are not protected under the regulations of the ordinance, the hearing examiner can grant a rent increase of up to 15% for each additional person that is there that is not protected under those regulations. So that's an option that landlords have to file. I think this is one of the most common ones. This is a very common one. Then there is attachment C, which is the petition to increase the maximum allowable rent, or the MAR, due to an increase in space or services. So the most common example is the tenant only had 1 parking spot in their lease, and they asked the landlord for another parking spot. So the landlord can grant it, but they say they want additional rent for it. However, because the rents are regulated by the rent program, the landlord can't simply say, okay, if you want an additional parking spot, give me $200 for it. That's not allowed. What needs to happen is that the landlord needs to petition the rent program to add an additional parking spot Therefore, it can be added to the rent. So this is really important to know, because I see a lot of cases where the landlord has given the tenant additional space or additional services, but they never got it approved through the rent program. And technically, the rent program controls everything related to the rent. And so I think sometimes landlords don't realize this. And so they'll give them an additional garage and they start charging the tenant $100, or they'll give them an additional parking space and charge an additional $150. I'm just making these numbers up. But they never get it approved to the rent program. So the tenant can technically go to the rent program and say, this was never approved by a hearing examiner, and it might be considered excess rent. So it's important to know that any rent increases, even if you are providing additional services, need to be approved by the rent program, by a hearing examiner through the petition process. Any increase above the MAR, no matter how small, or if you are providing a bunch of additional services, need to be approved by the rent program. And sometimes it can be just like a rubber stamp, or what's considered an administrative approval, that the landlord files and the tenant says, yes, I wanted this additional service. I don't need a petition, or I don't need to go attend a hearing. And it's just kind of like an administrative approval to make sure that the rate that the landlord is charging is considered an appropriate market rate. But you do need that approval. So that's really important to know. So let's move forward on how to actually file the petition. So I think that's why everybody is here today, to learn how to file and actually be involved in the process. So just do a little quick overview, right, of the petition process. So the rent ordinance allows for rents to be regulated and adjusted through the rent adjustment petition process, which is overseen by a hearing examiner. So you can think of a hearing examiner as a judge. The process is similar to court, but the process is less formal, as it is an administrative process performed and completed through the rent program and its staff. So all the petitions are filed through the rent program, and the hearings right now they're being done through teleconference, but before the pandemic, they would be done at a conference room in the rent program. So it's kind of like a quasi court. Landlords or tenants subject to the rent control provisions of the rent ordinance may file a petition requesting a downward or upward rent adjustment. After reviewing the documents and listening to testimony, the hearing examiner may order an adjustment to the rent if the petition has proven their case by a preponderance of the evidence. So this is important, right? Which is more than likely 50%. So anyone that is petitioning has the burden of proof to prove their case, right? To provide documentation, supporting evidence of their petition. Okay, so let's go ahead and move forward. So what are the steps to filing a petition with the rent program? So the first step, and this is one that we usually always recommend to anyone that's interested in filing a petition, is to contact the rent program and speak with the housing counselor. So that'll be me, or Monica, who is also here and who presented me. So she is another rent program services analyst. So you'll speak to either one of us, right? You'll let us know what the situation is, what the problems are, and we'll let you know, like, okay, I think you can file a petition and follow these steps. We can guide you through the process and send you the links to the forms. So that's very important, right? We can check if you qualify, if you are someone that's under rent control or someone that might fall under rent control, and if the petition process is something that's adequate for you. The step 2 is to actually complete the forms, right? So the first step is to complete the landlord or tenant packet. So when we go to the actual, when I show you through the forms, we're going to be walking over through these forms, but that's the step 2, right? This form must be completed and filed to be deemed complete. So sometimes we get petitions where only the attachments are sent, right? Which the attachments are the specific issues, and the general packet is inserted. The step 3 is to complete the appropriate attachment, right? So those are the attachments were the examples that we went over, which was attachment A, B, and C. So tenant or landlords can petition for multiple grounds at the same time. So what this means is that when you check off, or when you're filing a general petition, you can petition for multiple issues. So if you're on a tenant, you can, fill the general tenant attachment packet, But you can also say, okay, well, I have excess rent and I have habitability issues. So you can file both those attachments under the same petition. The same thing with being a landlord. If you're saying, oh, well, I think my tenant has additional people living there, so you would file attachment B. And also, I'm providing them additional parking spot. You would file attachment C. So they don't have to be separate petitions. You can file both attachments under the same petition.
Looks like we may have lost Magali, so just take a moment. Having a slight technical difficulty. Sorry about that, folks. We'll just give it a couple of minutes. We're trying to see if we can get Magali back on. If not, the staff member will take over and we'll continue the presentation. Okay, looks like we have Magali back on.
Okay.
Okay.
Apologies for that. I think I just quickly logged off, but everybody was still on, correct?
Yes, we still have participants in the webinar.
I don't know. Okay, great. So I had left off on step 3, correct? Complete the appropriate attachment for tenants or landlords. You can file a petition for multiple grounds at the same time. So next is step 4, which is, like I said before, any petition that is filed, you would need to, as a petitioner, you would need to provide a preponderance of the evidence to support your, you would have to prove your petition with the preponderance of the evidence, which is more than 50%, which just requires you to include documentation or evidence to support the petition. So some documents that are always used, or some documents that are good to use, is the lease, any letters, right, correspondence between the landlord and the tenant, emails, texts, photos, videos, inspection reports, or any other documentation to support the grounds for the rent adjustment petition. So remember that the hearing examiner's rent adjustment decision is based on the preponderance of the evidence. So the hearing examiner is going to make a determination on the documentation and evidence that is laid in front of him, right? So step 5 is complete and submit a proof of service to the rent program and all parties. So this is extremely important. This is one of the things where I see people, they skip the step or they don't fill it out correctly, and that just kind of takes them a few days longer to complete. So an important part of the petition process is the requirement that a petitioner must complete and submit a proof of service along with the completed petition packet. And when you submit the proof of service, the petitioner is declaring under penalty of perjury that they will serve a copy of the petition that was submitted to the rent program to the other party. So essentially, everybody has the same documents, right? The petition process is a transparent process. So I, as a petitioner, will give a copy of what I'm filing to the rent program to the other party, whether it be the landlord or a tenant. So I will have a copy, the landlord or tenant will have a copy, and then the rent program will have a copy, and we will all have a chance to review those documents. And so the proof of service is where you're certifying under penalty of perjury that you have done that. And so it's a very important step. So once you are at step 5, you have completed the petition process. And then obviously the next step is step 6, which is to file it with the rent program. And you can do that by mail, or you can also do it by email. Given the pandemic, the email portion is added. And so the proof of service also there has been a section that has been added to the email section. So let's jump to the website so I can show you how to find these forms and just kind of quickly give you an example of how these forms are filled out and give you some tips and guidance on how to properly fill them out. So we're going to start off at going to our website, which is www.richmondrent.org. Hopefully you can see it. Let me see.
We can see it.
You can see it?
Mm-hmm.
Oh, okay. I'm sharing the wrong thing. Okay. So this is our website. Let me go to the main website. So this is richmondrent.org. The other way that you can find it is you can just type it in Google Richmond Rent Program. But this is our main website. You're going to go to the left-hand side and you're going to go to Forms and Notices and scroll down or hover and then click on Petition Forms. So this is our petition forms website. All the information regarding petitions can be found here. As you can see, there are general instructions. The instructions that we just kind of generally discussed are on here. When you scroll down, you're going to find the petition forms for tenant use and then the petition forms for landlord use. Each petition also has filing instructions, so that could also be helpful. So it kind of breaks down the steps. So you can click on that. Today, I'm just going to focus on the actual petitions themselves. So we're going to give you a brief example of the tenant petition packet and do an attachment. And then we're going to do the same thing for the landlord petition forms. So let's start off with the tenant. So the first thing that I mentioned is the tenant petition packet. You're going to have to fill this out. And so what this does, it just kind of gives the hearing examiner general information about the property and the situation. So the first, right, you would fill out the address. If you are Spanish speaking or speak another language other than English, you can check if you require interpretation. And then this is a section where you would put the grounds for petition, right? So here is attachment A, B, and C. So this is an important section to remember because the hearing examiner, or the part of the due process, is the petition is allowing him to review the problems that are being checked in the petition. So for example, if I put excessive rent, but I also have habitability issues and I want to discuss that in the hearing, but I never checked attachment B, the hearing examiner is not going to be able to discuss that in the hearing because there is no attachment B, or that box wasn't checked off. And so the other party never received any documentation. And so it's part of the due process. So if you want to file multiple attachments or you have multiple issues, it's always best to simply check the box and attach those documentations, right? It's better to be safe and sorry and have a wider scope. So here we'll do attachment A and attachment B. Unfortunately, we don't have enough time to go over each attachment, so I'll be picking one attachment to go over for the tenant section. Here is the tenant information. So, any of the tenants that are involved will need to be filed, or their information will need to be listed here. It gives you space for 4, but if there are additional tenants, you can always add the page. Obviously, if you want to be included in the petition and, potentially there's a decision that is going to be rendered in your favor, you want to make sure that you're included and all of your information is listed here. The next section is the rent history. So this is important because it's going to determine the base rent, and it's going to let the hearing examiner know how much you're paying. Are you paying excess rent? Right, so goes back to the base rent, which is what the tenant was paying on July 21st, 2015. And then if your tenancy began after July 21st, what was the rent you paid at the time you first moved in, right? So this is going back to what we discussed. And then also it's going to ask you, what is the current rent? So the rent you most recently paid, and just providing the hearing examiner with information around your rent. This is going to, then you need to file the landlord's contact information. So as you can see, that's required. And the reason why it's required is because of the administrative process. So the rent program is also going to be sending documentation to the landlord once you have filed the petition, letting them know like a petition was filed. These are the steps that you need to take. And so that's why you need to have that information. So it requires name, phone, the business address, and just general, business email. If there is a property manager, you could also put that information. Sometimes tenants have the property manager's information and don't have the landlord's. I always tell tenants to make sure you get as much information as possible so you can properly serve them and go through the petition process. And then sometimes tenants will have a representative. This can be an attorney or an advocate. So if you do have a representative, you would add that information here. An important tip here is to make sure that all involved parties, right? So like when you go here, sometimes people will list 4 people, but then only one person will sign off. And then when reviewing the petition, it's kind of like, but you listed 4 people, why haven't 4 signed and printed their name and dated? So sometimes the petitions get returned for that. So that's an important tip, to make sure that all involved parties, if they are listed, their name will need to be shown with their signature and the date that they signed. As you scroll down, we get to the proof of service that we were discussing. And so again, this is letting the rent program know that the tenant has served the opposing party, in this case, the landlord, right? And so they'll indicate that they're a resident of Contra Costa County on the date that they served the tenant petition packet, and then what are the attachments. So in this case, I did attachment A, I did attachment B, and let's say I delivered it to the landlord's address. So you will put the person's name, and then you'll put the address that you sent it. The same thing if you placed it in the mail, you'll put who you sent it to and what the address that you sent it to. For delivering is who you gave it to and the address that you left it at. And this is what I was talking about, that because of the pandemic, there's a new section where you are allowed to email it now. So you would print the landlord or the property manager's name and the email address that you sent it to. And then lastly, you would be declaring under penalty of perjury, right, that everything that you put forward is foregoing and true, and then you would sign, date, and your name. Down here, you can see the little note, right, that this is a special proof of service where the email has been added and it's due to the pandemic. The email section isn't usually how the rent program has a proof of service. Right, so once you complete this packet, this is a general tenant packet or the tenant petition packet for multiple grounds. And then once that has been done, you'll move forward with the attachment that you want to do, right? So if we go back to the main web page, let's just do attachment A. So the specific attachments are they're more specific to the issue, right? So for tenant attachment A, you can do excessive rent complaint due to overcharges. And this is because the base rent was never rolled back, or um, the landlord is overcharging in the maximum allowable rent. The other reason why you could file a petition if you are a unit that is under rent control is if there is an increase in your security deposit. So under the ordinance, the security deposit is considered rent. So if sometime in the middle of your tenancy, the landlord decides to up your security deposit, that's not allowed under the ordinance and the regulations. And so you can file a petition saying that there is an increase in your security deposit that can or may be considered a rent overcharge, because the security deposit is considered rent. So that is another option. Although it's not as common, it is an option that you can fill out. So again, some of the information on here is a little bit repetitive, but please make sure that you fill everything out, because if you don't, it might be sent back and considered incomplete. So it's going to ask you again for the property address, the first day that you rented the unit, right? What was your monthly rent, right? So potentially the base rent, your security deposit, how much. So it's just going to ask you a lot of general questions and information about your tenancy. Then there's going to be the section of the changes in the rent. And this is important because this is going to let the hearing examiner know, right? Like, when was the increase given, how much the increase was for. And so this allows a hearing examiner to get a better idea if you are being charged excess rent, and when was the excessive rent done, and then by how much. So we can say I got a increase of $100 or $200, which was done on 1/20/19. Oh wait, no, sorry. That's increase number one. The increase was the new rent. So my new rent was $1,200. And if we go back here, right, and I put that my monthly rent when I moved in was $1,000, or if my base rent was $1,000, and I'm showing that my new rent paid was $200, it's very likely that I'm being charged excess rent because of how much the AGAs have increased. So the AGAs are about 3% every year, or the highest has been is 3.6. Last year was 2.9. So that's about a 16% increase within the last 4 to 5 years, right? So that 16% increase would be $160. So at a quick glance, I can see that the base rent was $1,000, and now this tenant is paying $1,200. So that's going to give the hearing examiner some idea. It's not right. It's not like a final answer, but it just kind of gives an understanding of like what the rent charges, especially let's say like there are more. So that was my first rent increase, but a year later, 1/20/20, I received another rent increase, and I'm paying $1,300. So I've definitely seen cases where tenants are being overcharged like $1,000. And so this just kind of lets the hearing examiner know what the actual increases have been. It's going to ask you if you received a notice of rent increase. If yes, did you think the landlord could have taken that AGA, or they shouldn't have taken the AGA? And this kind of leads to like if there are other issues in the unit. So sometimes there are habitability issues in the unit. So you might have said, I don't think the landlord should have taken a 3.5% because I have all these issues in my unit that were never addressed, right? There was mold, and I don't know, the gate was broken, or the window was broken, or whatever the issue is. So you can address additional issues through the AGAs. And it's going to ask you other reasons that your rent cannot be increased, right? So if you can say, oh, well, the landlord is not in compliance with the rent program, they haven't enrolled the property, they haven't paid their housing fee. So there can be other reasons, or other claims of rent overcharges, right? And so if there is any reason you believe you paid too much, which includes the landlord's refusal to give you your security deposit, or to make reasonable repairs, either by the landlord or the tenant. Please explain. And it has a quick note here, which it's attachment B may also apply if the landlord failed to make reasonable repairs. So this petition also is leading to you filing an attachment B if you do have claims for rent overcharges related to habitability issues or, lack of substantial repairs. And then the last section is the rent refund. So the petition is going to ask you, how much do you believe you're entitled to, right? And you can have a number, right? You can say, I believe that I was being overcharged $100 each month for the last 2 years. Or you can also say, I have no idea. And so just make sure that you put a number, right? If you think I'm being overcharged $1,500, or you can put, I don't know. I need help with the calculations, but make sure that it's filled out. You want to make sure that you put as much information as possible, so you let the hearing examiner know. The same thing if you received a security deposit increase, how much your security deposit increase for. So in this scenario, it's 0. How much do you want? What are you proposing that your rent be reduced, right? So if you're saying, well, I believe that the owner owes me $1,500. I want $50 reduced for the next 3 years. Or I want $150 reduced for the next 10 months. So what is it that you're proposing? And then the total rent refund that you are requesting, in this case, it would be $1,500 because there hasn't been a security deposit increase. So that's just kind of like all the information that is being requested of you. And then at the bottom, it's also asking you to print your name, signature, and date, right? So you are signing under penalty of perjury, that all the information that you're providing is true and correct to the best of your knowledge. And so this is going to complete the attachment A portion. Towards the bottom of page 3 is going to ask you to provide a summary. And this is really to help the hearing examiner understand what is going on and to just give context of the situation, when you received the rent increases, how much they were for, and just kind of gives the hearing examiner a summary of everything, and it helps him review the case. And then it's going to ask you to attach copies or, your rental agreement, notices of rent increases, any documentation that you have available to help your case. So once this is done, essentially the last step, right, it would be to add documentation, and that would complete your packet. You can send it over to the rent program. So the next thing that we're going to do is we're going to jump over to the landlord section. So let's go back to the main web page. And so we're going to scroll down to the landlord section. And the landlord petition packet for individual rent adjustment is pretty similar to the tenant one. Again, this section is just like a general form and is providing the hearing examiner with general information about the property, right? So what is the property address? Are there any other petitions for this property currently pending? If yes, describe the petition. Are there any exemptions that you have on this property, or are there any owner occupied units? So, right, if you have like a fourplex and you live in one of the units, that unit is owner occupied. So one unit is owner occupied out of the fourplex. So it's just asking you general information. Again, it asks you an interpretation is necessary. And it's going to ask you what the grounds for the petition are. And so this is similar to the tenant petition, right? So the landlord could petition for multiple things. They could be petitioning to receive a fair return. The M&I petition is for the property as a whole. So the M&I petition does an analysis of the property. So it's possible that if it's a fourplex, the landlord is requesting an M&I petition as a property as a whole, but they're also saying, well, in unit 3, I also have an increase in number of occupants. And then in unit 2, they have requested that I add a parking spot. So in this scenario, the landlord is potentially having 3 attachments, and they can, instead of having 3 different petitions, which would take months and months and a lot of paperwork that you don't want to go through, the landlord is able to say, okay, I'm going to file all 3 attachments under the same petition and have it done at once. And so that's important to make sure that you're addressing the situations. But similarly, let's say you only file for the MNOI petition, but then you get to the hearing and then you're saying, well, I think that the tenant has additional occupants. Well, unfortunately, the hearing examiner is not going to be able to address that issue because it was never added to the petition. And so it wouldn't be complying with the due process, right? That everybody gets the documents, that everybody sees what the petition is for. And so similarly, it's important to make sure that you're addressing everything that you actually want the hearing examiner to address and be discussed with at the hearing. So let's scroll down. It's going to ask you landlord information. If you have an agent, provide the agent information, right? So sometimes there are more than one owner, so it asks you to provide the owner information. And then one thing that's a little bit different, it's going to ask you for the information for each individual unit, right? So if this is a fourplex, you would list the information for units 1 through 4, right? If you live as an owner, you live in the same one, you would put the landlord's information, right? Say this is landlord occupied, and then you would list the other units, right? So Magali Chavez lives in unit 2, and then you would put when my tenancy began. If it began on January 20 of 2015, what my base rent was, what was the tenant paying in July 21st, 2015, was $1,000, and right now that tenant is now paying $1,100. So it's just asking you for general information about the tenancy. If somebody else lives there, you would name the other tenant, and you would do that for all the units on the property. So moving forward, right, you would declare that the property has been properly enrolled. So as part of the petition process, or landlords are required with the rent program to enroll the property, to register the tenancies, to pay the rental housing fee. And also they have different requirements with the city, right? So they would need to have a building license, a business license with the finance department. They would need to be enrolled with the residential rental inspection program. If it's a fourplex, they would need to pay for the fire prevention services fee. So what this petition is saying, or what you are declaring, is saying that you are in compliance with the rent program and all other requirements with the city before you file a petition. Because if you want a rent increase, right, if you're requesting a rent increase, you first need to be in compliance to request a rent increase. So that's what you're declaring. You would sign and print and date. And so you'll be doing that for the owners. And if the agent is available, you would also be doing that. And then we get to the proof of service. So similarly to the tenant petition, the landlord petition could be a little bit more complex. So for example, if you have a fourplex, every single unit needs to be served with the petition. So you would have different petition, right? You would have different people that you would be delivering it to. Your information would be the same, right? Depending on where you live. If you live in Contra Costa, on what date you served, what attachments you served, but also who you served. So if it's a fourplex, you would be serving multiple people, because everybody, all involved parties, need to have access to the documents that you submitted to the rent program. So you can do that by in person, you can do it by mail, or you can do it through email. And then at the bottom, you would sign under penalty of perjury that you have delivered the packets to all involved parties, and sign and date. And so this would complete the landlord petition packet for the rent adjustment. And then from here, the next step would be to file or to fill out the attachments. So let's jump back to the petition's webpage. The attachment A is an important petition, but because of the complexity and given the sake of, for the sake of time, we will not be going over this attachment today. If you are interested in filling out an MNOI petition, I would highly recommend that you contact the rent program and speak with the housing counselor. And also this petition requires additional assistance, right? Usually from an accountant or a CPA, because it does involve a lot of math and it has a lot of different requirements and documentation. So it's definitely not an easy petition to go over and to complete. So if you have specific questions about that, contact the rent program. Today, we'll be filling out the increase in number of occupants allowed. It's actually one of our most common petitions, so I think it'll be useful to go over the most common petition. So the landlord attachment B, essentially what it does is it provides the landlord with an increase of up to 15% if they have additional occupants that were initially than the amount that were initially allowed when the tenancy began. Like I said before, there is a caveat to that. And so I highly recommend that if you're interested in filing this petition, that you will read all the instructions. The caveat is here, which is that no increase in the maximum allowable rent will be given for any additional occupants that are essentially like nuclear family members, right? So if the tenant has a spouse, if they have additional, if they have a registered domestic partner, if they have a child, right? Like they had a baby, initially there was 2 people and then they had a baby, so now there's 3. You can't petition for an additional increase for a baby, right? If they add their grandchildren, parents, grandparents, legal guardian of a child, so things like that. So the other one is if there's a caretaker or attendant as required for a reasonable accommodation for a person with disability, right? The mark can be increased, but only if the tenant agrees in writing. So that's an important caveat. So if, like, let's say there's 2 people living there and then the person has a baby, but the tenant never agreed to an additional rent increase. If you file a petition and say like, oh, well, now there's 3 people because there's now a baby, there is an added baby, it's highly unlikely, I would say almost 100%, that the hearing examiner will say, well, the tenant never approved a rent increase. This type of additional person is, or additional occupant is exempt from the rent increase and protected under the regulations. And so it's important to read the regulations and understand, because the hearing examiner is bound by the regulations. Like he is interpreting the facts and the evidence in front of him and making the decision based on the regulations, or how it allows them to. So we're going to go over some quick definitions that are important. So these, you'll see that it's column 3 to 7. These are going to come into effect later on when you go through the petition. So it's listing out the columns here. So the first important thing is the base occupancy date. And so what that means is that when the tenancy began, right, so it's at the starting of the tenancy. Column 4 is a base occupancy level, which means the maximum number of tenants allowed or that were occupying the unit as a principal residence on the base occupancy date. So essentially when they moved in, how many people were allowed to live there. Then there is a current occupancy rate, which means the number of tenants currently occupying the unit as a principal residence. It's going to ask you for the maximum allowable rent and the rent increase that you are requesting, or the percentage increase in rent being requested for 1 or more occupants if approved, right? And the regulations allow for up to a 15% increase. So scrolling down, it's going to ask you for the landlord information, basic general information, name, address, and your email, and then if applicable, agent information. Then, like I said, it's going to ask you for the occupancy level chart, right? So let's say it's unit 1, there is 1 additional person. That person, we're going to use the same mates, moved in on 1/20/2015. When they initially moved in, I allowed 2 people. Now there are 3 people. Their maximum allowable rent is currently $1,100. and I am requesting an increase of 15%. So that is essentially what the information is requesting of you. You can do it for multiple units, right? So if you have a fourplex and there have been additional occupants for units 1 and 2, you can do it for all of those units. So that's important to know, but this is generally pretty straightforward, and the information that it's going to be asking of you. Then you're going to, when you scroll down, it's going to explain all facts supporting the basis for this petition. So sometimes it's pretty straightforward. It's kind of like, oh, well, the tenant has two people live there, and now they have requested for me to add a third person. And I am leaning towards approving it, but I want to get permission from the rent program first to get the rent increase, right? So you can put that scenario, and then you would attach, if the tenant sent you an email, right, you would attach that documentation. Sometimes it's not as straightforward. Sometimes the landlord has a hunch, or they believe that there are additional occupants, and that might get a little bit more murky. So what information or what supporting evidence do you have to prove that there are additional occupants? So sometimes landlords say, well, I live in the main unit, and I continuously see an additional person, that comes and they sleep there. They are always there, and I never approved them to be a tenant. So something along those lines, and you can provide, whatever documentation you have for that. Or, I asked the tenant, and they admitted that person is living there, and this is their written proof. So it really just depends. It's a spectrum, and you always want to have as much documentation and proof for the petition, because the burden of proof is on the petitioner. So you, as a landlord that is filing, the burden of proof is on you to prove that there are additional occupants in the unit. Right? So you would describe the scenario here, and then you would provide additional documentation. So the obvious ones is the lease, right? Showing how many occupants were allowed when the tenant moved in. If you have any relevant correspondence, if you have letters, emails, text, if you have photos, if you have, recordings. So any type of documentation that would help your case, you could add it to the petition. So once we're done here, let's scroll back to our presentation, just to kind of do a quick overview. Right, so once we have completed our general petition packet, and we have completed our general attachments, we have completed our proof of service, and then we have added supporting documentation. The petition is ready to be sent to the rent program, and that would be step 6, right? You can do that through mail or through email. And to do a quick overview, this is what a completed petition would look like for a tenant, and a completed petition will look like for a landlord. As you can see, they are both pretty similar, right? There is the general landlord or tenant petition packet. There are the petition attachments that the landlord or tenant would attach or check the box, right? There is the proof of service that they would need, both petitions require, and then there is the supporting documentation. So you have compiled your petition, you have served all the relevant parties, you have submitted to the rent program. So what happens next? So let's discuss a little bit what happens after, or let's discuss a little bit of the petition process. So once the petition is received and reviewed for completion, the other party is given the opportunity to object to the petition. And so what this does is the rent program will send documentation to the other party, and it lets them know that they have 21 days of the mailing of the notice to file a objection to the petition, right? So if I am a landlord that is filing for additional occupants, and the tenant is going to object, they can object and say, oh, the additional person that's living here is actually my husband. We just got married. Here is our documentation. The other party, or if I am a tenant that is filing and I'm saying that this is habitability issues, the landlord can object and say, no, that was already fixed. That was fixed immediately and timely. Here are pictures showing how the unit is currently. Whatever your objections are, you will send the objection packet to the tenant or to the landlord, the opposing party, and you will also send the objection packet to the rep program. So again, the other party will also be responsible for giving any documentation back, right? So like the point is that it's a transparent process, and whatever documentation the hearing examiner has, all involved parties will also have. So I think that's how to remember, because I know the whole survey back and forth is a little bit confusing, but the idea is that it's a transparent process, it's part of the due process, and so whatever is served to the rent program will be served to the opposing party and vice versa. So after the 21-day objection deadline is over, or the objection has been filed, the rent program will send over a settlement conference and hearing notice, right? So essentially it's letting you know when the settlement conference and hearing notice will be scheduled. And the hearing notice will be sent to all parties. When you receive the notice of when your hearing notice is, and you're like, this date doesn't work for me, either party can request a continuous in writing. So you can, Cynthia Shaw is a person that oversees the petition process. So she is more likely the person that you will be in contact with. If you are involved in a hearing, her information will be listed on the notices. So after the hearing, right, so I have gone through the hearing and a decision has been rendered. The decision can be appealed by either party within 30 days or 35 days if mailed of the decision. So I went through the hearing, the decision has been rendered by the hearing examiner. I don't agree with this decision. You can file an appeal with the rent board within 30 days or within 35 days if the decision was mailed. So what happens the day of the hearing, right? And I'm not going to go over all of this in detail. It's just kind of so people that are involved can have a little bit of context of what occurs in the hearing. I know that because this is an official process, sometimes people feel nervous, and just having that information helps them to be prepared and prepare for the hearing. So, right, the first part is to have expectations and preparations. And what this means is that before the hearing starts, each party must introduce themselves for the record. The hearing examiner may not discuss the case unless all parties are present. And the settlement conference and hearing can only proceed if all parties are participating, unless there is a complete failure by another responding party to show up. And so a failure to appear by the petitioning party will generally result in a dismissal of the petition. Part of the hearing or the settlement conference process is that first you can discuss a settlement. So the settlement is essentially the hearing examiner is not making a decision. What he's doing is he's facilitating a conversation between both parties. So if both parties agree to enter into a settlement discussion, they can come up with an agreement the day of and come up with the settlement, and a settlement agreement will be written by the hearing examiner and given to both parties. A settlement agreement cannot be appealed. So that's important to know. But if both parties are interested, it's a good way to resolve the issue the day of. And most times the cases are settled. There are a few where a decision is rendered. So that is an option, right? If you want to enter in settlement discussions, you can. If either party rejects the settlement discussions, then it'll go to a hearing. And then we'll begin is that the evidence will be submitted with the petitions and the objections. If there is any additional documentation that is going to be entered, it will be done there. Part 4 of the hearing is cross-examination, right? So the hearing examiner will ask questions to the parties involved about their pre-filed testimony or evidence to better understand the party's position in the case, or ask questions to challenge their credibility or accuracy, right? So if the hearing examiner sees something that he thinks is strange, or the timeline doesn't make sense, or just the hearing examiner is just trying to gather more information about the case to better understand the case and make a decision. After that, there is the rebuttal. right? So, and this is based on the hearing examiner's discretion. Again, the hearing examiner is like the judge, so he is controlling the hearing as it goes. But each party will have an opportunity to contradict evidence presented by the other party. And then you can present evidence to say, well, that isn't correct, right? And it's the basic text, photos, any type of documents in rebuttal to disprove or rebut new evidence presented by the other side. And then part 6 will be the closing arguments. The hearing examiner will close the hearing, or they can also decide to keep the case open for further analysis to later make a decision. So this is rare, but sometimes it happens where the hearing examiner thinks that they need additional documentation, or sometimes like something was brought up, but they're like, I don't have the documents now, but I can send it. So sometimes the hearing examiner will leave it open for a week or two for either party to submit additional documentation, and then that'll help him make his decision. So that also occurs. So that's kind of part 6 of the closing arguments, and that's essentially what will occur the day of the hearing. Once the hearing is done, assuming that a settlement, like the parties do not come up with a settlement, and it is chosen for the hearing examiner to make a decision, the other step after that is appealing the decision. So after filing a petition, and you have completed your petition, you have gone through the hearing, a decision has been rendered by the hearing examiner. Either party, they don't agree with the decision, they can file an appeal for the rent board. So any party can appeal the decision of the Richmond Rent Program hearing examiner within 35 calendar days after the date of mailing, right? And so on the appeal, the decision is reviewed by the rent board, which is a 5-member board. And think of them as like quasi-judicial judges, right? So they're also just kind of like a 5-person board, and they will be, the case will be presented to them. And they'll ultimately make the decision. And the board can affirm, reverse, or modify the decision of the hearing examiner. So filing a timely appeal puts on hold the finality of the hearing examiner's decision. So that's important, right? For either party to know that if like either party says, I don't agree with this decision, and it's filed timely, the decision that the hearing examiner rendered, it puts it on hold. So it's essentially not really implemented. You can file a late appeal, but if you do, you would state the reason in writing and include it with your appeal. But the filing of an untimely appeal does not stay any portion of the hearing examiner's decision. So this does not put it on hold. So after the appeal or a timely appeal is filed, the respondents or the involved party are informed by the rent program regarding the requirement to appear and participate at the appeal hearing. So all appeal hearings are done by the rent board, and this is done during the regular rent board meetings. So it'll be the rent board meeting, and then it'll be the appeal hearing. Currently, all rent board meetings are done, I believe, through Zoom. So you would present yourself. There's currently no public rent board meetings. So, and then if you go through the rent board appeal process and you don't agree with the decision, any party who wishes to appeal the rent board's decision can do so. They can seek a judicial review by filing a writ of administrative mandamus with the superior court within the jurisdiction. So at that point, if you appeal the rent board's decision, it's kind of like outside of the process of the rent program, and it'll enter superior court. So I know that this is a lot of information. I know that this is a lengthy process, but I believe we are done with the presentation. So moving forward, we are going to be hearing Q&A. Thank you for being here. If you have any questions, any specific questions about a case, contact the rent program. You can call us or you can email us. You can also visit the rent program and find information there. We are going to move forward with our Q&A portion. However, we are going to be focusing on general questions because of the time constraints, we cannot answer specific questions about your case. So if you do have specific questions about your case, please contact the rent program so you can speak with the housing counselor. And also make sure that you put your questions in the Q&A portion of Zoom, not the chat portion. Again, thank you for being involved. Monica, are you?
Yes, I'm on. So if you have a question, please type it in the Q&A section, and we'll go down the list as they come in.
So while I was presenting, I saw a few people raise their hand.
Yeah, so those folks that are raising their hand, they should type their question out into the Q&A box.
I see a few questions in the chat box. I don't know if you want to.
Oh, let's see. Okay, one of those questions are answered. One of the questions listed is if we have this information in Spanish. We will have the presentation available in Spanish in about 2 to 3 business days. We translate all our PowerPoint presentations, and they're located on our workshops webpage. I provided the link in the chat at the beginning of the presentation. So you may access the Spanish version, and we will also have a Spanish workshop in regards to how to file a rent increase or decrease petition later this year. I'm not sure. I believe the next one we will have will be November 19th. However, the PowerPoint will be available on our website. Okay, so we have a few questions that popped up. First question is, at this time during COVID, can petitions be filed by landlords to increase base rent or to petition for installing new floors in certain units in the building?
Yeah, so the petition can still be filed. So the flooring that you're referring is going to be part of the M&I petition. And what it's referring to is capital improvements in the M&I petition. And so if you are doing the repairs this year, you wouldn't file the petition until next year because of the reason that it works like taxes, right? So if you're doing most of the repairs in 2021, you wouldn't file until 2022. If you did all the repairs in 2020 or you changed the floor in 2020, then 2021 would be an appropriate, or 2021 would be the year to file it. So it depends on that. And yes, you can file the petition. It'll be part of the M&I petition process. And so again, it's not an automatic increase. What it's looking at is your net operating income compared to 2015.
Okay, great. Next question is, do you need to file a rent increase if you have a unit that's become vacant to rent it at market value?
No. So if there has been a complete turnover in tenancy, and the unit is vacant, landlords are allowed to raise the rent to whatever they want. So once the new tenancy begins, that is when the base rent begins, right? So whatever you charge the tenant when they first move in will be the base rent, and from there is when the rent will be regulated. So let's say you start your tenancy next month. I'm like, what month are we in? It'll be March. So your tenancy will begin in March and you charge them $2,000. Your base rent will be $2,000. There will be some caveats if there are like discounts, but generally speaking, the base rent will be $2,000. And then from there, it'll be controlled and the increases would be allowed based on the AGA.
Great, thank you, Magali. Next question we have is, a single family house on one parcel, is that exempt from rent control?
So like I said before, the single family house is not really the appropriate term to use. The appropriate term to use is how many dwelling units are on the property. So if there is only one dwelling unit on the property or on the parcel, then yes, it would be exempt from rent control. But if it's something that you consider a single family house and then there's an additional unit in the back, or the house is subdivided where there are multiple dwelling units on the property, then it's potentially not exempt from rent control, and there's a good chance that it falls under rent control if it was built before 1995. So you can always contact the rent program, to discuss this further. If you are a tenant and believe that, I think this falls under rent control because there's more than one dwelling unit, you would need to file a petition. If you are a landlord and want to say, is this under rent control or is it not, you would file an administrative determination with the rent program. So those are the options that you have. I would suggest that you look over the presentation that we went over, or contact the rent program to discuss the facts of your particular case.
Great. Next question is, if you void a lease and make an entire new lease, can you change the security deposit and rent without a petition?
So the answer is no. That's I guess, a short answer. Changes in the lease aren't allowed, right? So as an owner, a lease or a contract is an agreement between two people. So the owner cannot say, I am changing the lease, here's your new lease. The tenant will need to agree to a new lease. And because a tenant has just cause for eviction protections, not writing a new lease or not agreeing to a new lease is not just cause to evict. Similarly, not agreeing to a new lease is not reason to raise the rent. So you cannot change. And then particularly, the tenant cannot waive away their rights, right? So even if the tenant agrees to a new lease, the tenant can agree to an increase in the rent. The only organization or the only person that has power to agree to a rent increase is a hearing examiner through the petition process. So any increase in the MAR has to be approved by the hearing examiner. And I know that this is really weird, and I think it's like a very different process, right, for landlords. I think a lot of landlords are shocked by that, and I understand that it's difficult to understand because it's going from a point in time where you could just raise the rent to market or to what you wanted, to now there's this agency that has to approve any rent increase that you do. But that's so important to remember, is that if there is any increase in the maximum allowable rent, it has to be approved by the hearing examiner through the petition process. So to elaborate, because I feel like this is a good question and it gets asked, even if the tenant agrees, right? Even if you're like, I want a new lease, your old lease was $1,000 and now I'm going to charge you $1,500. And the tenant is like, okay, I agree. And this is a rent controlled unit. The tenant can file a petition, and they can, if some point down the line they find out, oh, this unit is under rent control, you weren't allowed to charge me a $500 increase. And this is what happened a lot when the rent program began. You were only allowed to charge me 3% increase or whatever the AGA was for that year. They can file a petition, and you're potentially liable. You would potentially owe the tenant, right? Like if it's been 3 years, like let's say it's been 3 years and you've been charging the tenant excess rent of $500 a month, that's $6,000 per year. In 3 years, that's $18,000. So I have seen cases like this. These are obviously in the extreme, but I have seen cases where the tenant is granted thousands and thousands of dollars in excess rent because the landlord increased the rent and the tenant said, okay, but after some time, the tenant was like, wait, I don't think this is right, and filed the petition and won the case. So I will repeat this again. Any increase in the MAR needs to be approved by the hearing examiner through the petition process and a rent.
Okay, great. Thank you for that, Magali. Next question is there a current moratorium on rent increases? If so, when did it start?
So that's a good question. There currently is a rent moratorium on rent increases for rent controlled units. I don't remember the exact date. So the first moratorium was implemented by the City of Richmond. The City of Richmond had an ordinance. I don't remember the exact date. It expired September 30th
Mhm.
um, for the City of Richmond, but the Contra Costa County also had a rent moratorium. And I don't remember the exact date when it started, but the Contra Costa County ordinance has not expired. They just extended it February 2nd, and it's in effect until June 30th at the moment. However, um, that law has been extended several times, right? So it's developing as the pandemic develops. So right now it's June 30th, but it might go longer.
Next question we have is why is the security deposit considered rent?
It's how the ordinance is written. So it's part of the definition of rent under the ordinance. So that's what the voters approved, and that is what went into law.
Okay, next question is how do you prevent a tenant mutiny by asking for a rent increase for all units as they are all extremely low?
Um, well, the process that you would have, right, is to file a petition with it's an MNOI petition for fair return. So that is the landlord, what landlords have. Like if they don't have additional services or additional space, or there are no additional occupants, and your main concern is I have low rents, or the the base year comparison, the net operating income that I received in the base year, which would be 2015, is not meeting inflation, right? It's not the net operating income that I receive now, adjusted for inflation, is a lot less than I received in 2015. You would file the net MNOI petition, maintenance of net operating income petition, right? And so that petition reviews all of the units. It reviews the entire property, um, and it'll be the hearing examiner's decision. And so the hearing examiner will obviously the hearing will allow the tenants to show up and the landlord to show up and take testimony for both parties. Sometimes I have seen MNOI petitions where like the tenants show up and sometimes there's issues like about habitability, right? That they're upset that the landlord wants to raise the rent, but they have all these issues. So sometimes there are compromises where the landlord says, okay, um, the hearing examiner will approve the MNOI petition, but with certain criteria that certain things need to be fixed. And so that kind of helps the situation, right? And I guess that's part of the petition process. It allows for both parties to come to a decision, to speak their mind, to bring forward their evidence. But if you are a landlord who thinks that they are not receiving a fair return, the MNOI petition will be the tool to utilize for that.
Okay, great. Next question. We received the same question. Is there a current rent increase moratorium in California? But additional questions include when is the earliest date a rent increase can be requested? Also, with the rent increase moratorium, how do we bank the 2.9% increase?
So the moratorium is not in California. The moratorium is in the Contra Costa County. So it's a county law right now. It's a county, Contra Costa County ordinance. There used to be a Richmond ordinance, but the city of Richmond decided to let their moratorium lapse. When will be the first day that you can take a rent increase? I don't know. Right now, the Contra Costa County is set to expire June 30th. But like I previously mentioned, the Contra Costa County ordinance has been extended several times, right? So like these laws are developing as the pandemic develops. So if we get to June 30th and the pandemic is still ongoing, I think there's a pretty good chance that it'll get extended. If we get to June 30th and most people are back to work, like the economy has recovered, there probably is a chance that it'll get lapsed and landlords will be able to take their rent increases again. It's highly unknown. It's based on the pandemic. The third question is how will it be banked? So as a landlord, all landlords, you never lose the AGA. They get banked. So what will occur is that once you are able to take a rent increase again, what the banking regulation allows is to take 5% of your saved AGAs if you have 5%, plus the applicable AGA. So for example, this year it would be 7.9%, right? So like if I have never taken a rent increase, I currently would have around 16%. This is ballpark. I can take 5% and then of those saved AGAs and then add a 2.9% for the current year's annual general adjustment. And so the maximum that I can increase within a 12-month period would be 7.9%. On September 1st, we will get a new AGA, and so that number might get lower or higher, and that AGA will change. So, if on June 30th or July 1st, the ordinance expires, then you will be able to take up to 7.9% increase.
Great. Next question is, in 2015, our rents were very below market value. Can they be brought up to market value at that time? How is that determined?
So I think what the owner is referring to, right, is that they had a very low rent. It's sometimes what landlords refer to as like historically low rents, that they haven't done a rent increases, in the previous 10 years. And then in 2015, rent control hit. So again, this is part of the M&OI petition process. So the M&OI petition process allows you to challenge the base year. And so if there is, so I have seen I think a case, right, where the landlord argued that in 2015, their base year was really low because they had exceptional circumstances, and those circumstances was that they hadn't taken any increase in the previous 10 years. And then they decided to raise the rent in 2016 and 2017, but then the rent ordinance went into effect and made them roll back their rent back to July, what the tenant was paying July 21st, 2015. So their argument was that, they had a very low rents and the base year was not an adequate representation. Proving this is very difficult, right? So it requires a lot of documentation. It requires information about what the rents in the area was. I believe, so if you look at attachment A, which is the M&OI petition process, I believe it's like pages 19 and 20. Let me pull it up. So if we go to attachment A, it is, page 19, right? So claim for adjustment as base year gross income. So this would be the section where you would challenge the base year, right? So the calculations is based on the base year, comparing it to the current year. And so you can say, well, the base year is not an adequate representation of what the rents would be. And so there is section C, right? So petitioners submitting a claim based on comparable rental units during the base year will be required to pay for an independent appraisal by a real estate appraiser with the capacity to perform the required analysis of analyzing comparable rental units during the base year. So it's going to require a lot of documentation. You will need to hire an independent appraisal. And this is what I'm saying, that the M&OI petition is not easy, okay? So it's going to require a lot of documentation. You're going to need to hire additional people to help you with it, usually a CPA or an accountant. If you're challenging the base year, you're also going to need a real estate appraiser. And so it's not going to be a fast and easy process. The petition itself is pretty complex. And so if you are thinking of doing an M&OI petition, I highly encourage you to read through attachment A. So this is attachment A, so you understand what is required of you. The most important section is pages 6 and 7, right, where you're proving your income and operating expenses. And another resource that is available to you, this is why I like Zoom, because you can just show people, is if we go to the main page, Richmond Rent Program, you go to laws and regulations, and then you go to our chapter 9, which is standards for individual rent adjustments. And then it is 905. So 905 is the maintenance of net operating income fair return standard. And so these are the regulations that the hearing examiner is going to go by. Similarly, the other regulations regarding changes in space or services are on here. And then changes in number of tenants are on here. So if you are a landlord, Chapter 9, standards for individual maximum allowable rent adjustment, is very important for you to read through. And it's a very helpful resource. Monica, if you don't mind putting the link on there. Yeah, great. So that is something that you would want to read if you're interested in filing a petition.
Great. Thank you for that, Magali. So I just dropped that link, the laws and regulations that Magali referenced. Feel free to click on it and take a look what she just went over. So the next question that we have is, when the rent board was established, there was some talk about base year rent. How do we find out what that is?
Well, your base year rent. So I think this person is going to have to rewrite their question, because the base year rent, as described in the M&OI petition, is the rent that you were collecting in 2015. So if we go back, right? So it's the rent as a whole that you're collecting from the property, and for a specific unit, the base year, it's the base year rent, or the base rent for a specific unit is what the tenant was paying on July 21st, 2015. If they moved in after, it's what the tenant was paying the first month that they moved in. If you're referring as base year rent as part of the calculation for your net operating income, the base year rent is the amount that you were receiving from the property from 2015. That's what's considered a base year rent. There are some exceptions where, like, the landlord has already done an M&OI petition, and they're doing now a second M&OI petition, and so the base year rent will be the current year. So those definitions are in the regulations. So if we go back, to section 905, base year, right? For the purpose of making fair return determinations pursuant to this section, the calendar year 2015 is a base year. The base year CPI. So that's what the base year rent is the rent that you're receiving in 2015 from the property. And so all these definitions are here. And if you're considering an M&OI petition, it's important for you to understand, right, what is presumed as fair base, because sometimes people think of a market rate, and that's very far from what the regulations stipulate, what the regulations consider a fair return. So I would recommend that you read those definitions.
Great, thank you. And I also dropped in that link of Chapter 9 regulations directly. So if you need to look up those definitions, it's available at the link. The next question is, how do you decide what a fair rent is for a given unit or units? Are there any guidelines or any criteria that we can refer to?
So if you're referring to fair rate, or as like, so I'm going to answer this two ways, okay? So if you mean fair rate, or like as to what you should charge like a new tenancy, right? So like you have a vacant unit and you are and you are leasing it to someone new and you're like, I don't know what I should charge, I would recommend that you look at Zillow, or I think Redfin, right? So I would recommend that you go on Zillow and then just kind of type in, if you have like a 2-bedroom apartment in, I don't know, 94804, the zip code, you will want to look up, what are the surrounding units charging for that unit. So you get an idea of like what the other units are charging or what the market rate for that unit is. If you are asking about fair return as it's described in the ordinance or the M&OI regulations, that's a very different description, right? So the fair return is here. So a landlord has a right to obtain a net operating income equal to the base year net operating income adjusted by 100% increase in the consumer price index since the base year. And I know that's very confusing. So essentially, this is going back to what I was referring to, right? That the M&OI petition, what it does, or what is considered a fair return, is it's going to take your net operating income from 2015, the base year, and it's gonna. And this is my example of like $100, and it's gonna say, okay, in 2015 there is no rent control, so the $100 that the owner was receiving, that's what the net operating income of $100, that's what they receive, that's what they view as a fair return. And then it's going to say, okay, now the current year is 2020. Adjusted for inflation, adjusting the net operating income for inflation, is the owner receiving the same amount, right? And so the amount in 2020 of $100, because the CPI has been around 16%, let's say it's $116. If the owner is receiving more than $116, that's when the hearing examiner is not allowed to give you a rent increase, because under the regulations and under the rent ordinance, the owner is receiving a fair return. If the owner is receiving less than $116, that is when the hearing examiner is allowed to issue a rent increase. So let's say the owner is receiving $108 for a fourplex. The difference is $8 between 108 and 116. And so each unit would get an additional $2 increase, assuming that all of the units qualify for a rent increase, right? Because some of them might be exempt, some of them might not be under rent control. This is a very oversimplified version of like how the calculation is done. It's just to kind of give you an understanding of how it works, because it's a lot more complex and there's a lot more numbers that go into it. And, like the petition is 20 something pages. But that's kind of what a fair return is. So if that didn't answer the question, because I wasn't sure what they're referring to, they can retype the question.
Okay, that was the last question that's listed. So we'll give it a couple minutes and see if others have any other questions.
Can I stop sharing? Yeah, right.
Yes. The question that popped up is, will this workshop be posted on YouTube? The answer is yes. Like I attached in the chat, the link to our workshops page and records all our webinars, and you can access them on YouTube. And just for reference, I'll go ahead and provide that link. Usually it takes about 2 to 3 business days for it to go up on our website, but you can always review it once we post it.
Oh, I just realized I was.
We have about 9 minutes, so we'll see if there are any questions. We'll wait until 5:52 or 5:53. Okay, we have a couple of questions up, or one question that came up. The question is, what type of work, if any, that's done to the building or a unit can be passed on to tenants, and what can't be passed on?
So I guess nothing can be directly passed on, right? So the time when a increase is passed on to the tenants is if the landlord has done capital improvements to the property, and because of the capital improvements, they have not received a fair return. And so that's when the analysis will lead the hearing examiner to um, allow for a rent increase. So I like I like sharing the screen. So if we go back to the regulations that we were referring to before, you can see my screen, right, Monica?
Yes.
Oh, they're right here. I already have them. But so there is an amortized list right here, right? These are all the things that are considered capital improvements that would be in that would have an amortization rate. And so, air conditioners, refrigerator, whatever it is, right? You would put that in the petition. But remember, this is for the current year. So if you are filing in 2021, only the expenses that you applied in 2020 will be considered, will be analyzed, right? The hearing examiner is not allowed to look at expenses from 2016, 2017, 2018, 2019. If you are looking at 2021, the comparison will be for 2015 to 2020. And so that's important to know. If you're looking to make repairs or to make, sometimes roofing or, foundational stuff that's like really big, make sure that you understand when the work is going to be done. If it's all going to be done in the same year, preferably in the same year, right? That it would be done in 2021. So then you file in 2022. And then when the rent increase is approved is when the analysis shows that you are not you're not receiving a fair return. And so capital improvements can be part of that analysis, but it can also be other things, right? Like if there's an increase in expenses, now we have the rental housing fee, if you had an increase in property taxes. So it's not a straight what can be passed on and what cannot be passed on. The hearing examiner is allowed to do a rent increase when the owner isn't receiving a fair return based on the regulations and definitions of the ordinance and chapter 9.
Okay, great. We had a couple more questions pop up. The next question is, you shared an example where a landlord could be liable for excess rents for several years. Is there any cap on how far back a tenant can challenge his or her rent increases?
It's usually a 3-year statute of limitations, but there can be exceptions. So if the owner was aware, but it's usually 3 years.
Okay, great. Next question is, capital improvements cannot be done because rents, I guess this was more a comment to your response. Capital improvements cannot be done because rents are so historically low and expenses for new roof only are about 60,000, but we need plumbing, kitchens, bathrooms, electrical, and more. But if you have specific,
Yeah, I'm not
question.
exactly sure. I mean, you can always file the petition, right? Like if you are not doing like if you're saying I can't afford to do capital improvements, but I have very low rents, you can file a petition. You don't need to do capital improvements. There is a section in the petition. Um, so there is, if I pull up attachment A, let me see. So if I pull up attachment A, there is a section in the petition that allows you to include future capital improvements. And so that way you'll have an understanding, you'll have an idea of what increases you're looking at, right? Are they doing the capital improvements? Should you do all of them? Should you do a little bit, the most important ones? So the petition process does allow you to list potential future improvements that you'll be doing. And based on the analysis that is done, will give you the rent increase. I hope that answers your question. So that is an option that you have, right? If you're kind of like, will it be passed on? Will it not be passed on? You can fill out this section without doing the capital improvements, or saying I need to do this in the future. What kind of rent increases am I looking at? And so this section does allow you to do that. But you would still need to do everything else. You would still need to fill out the entire petition as a whole.
Okay. Well, that was the last one, and we have about 2 minutes until this webinar is over. So if someone has a quick question, and otherwise, I think that concludes our webinar. Can wait a minute or so and see if any other questions pop up. Okay, I believe hearing none, I think that concludes our workshop for today. I just want to thank everybody for attending, and if you still have more questions, feel free to contact us by phone or by email and visit us on our main webpage. Thank you again, and thanks, Magali, for your presentation.
Bye, everyone. Have a nice weekend.
Goodbye, everybody.